Well, welcome everyone on that note to today's webinar. I'm Martha Rands. I'm the legal director of the Pacific Legal Education and Outreach Society, and I'm really grateful to have both Julie Macfarlane and Clea Parfitt back for a conversation, this time not about harassment processes, but rather the non-disclosure agreements. What are they and how do we ban them? And so we're going to have a very spirited conversation with the two of them momentarily. I'll take this time now to acknowledge that I'm coming to you from the lands of the Coast Salish people, the unceded traditional territories of the Squamish, Musqueam, and Tsleil-Waututh, and that certainly from my point of view, as we work towards reconciliation, I thank them for their forbearance of our presence on their land for as long as we've been here. I am going to turn the mic, the controls to Julie Macfarlane, who's going to start us off today talking about her work to internationally to ban NDAs. And I'll allow her to introduce herself. Her bio is on our website. And then Clea Parfitt, our dear friend here in Vancouver, will enter into a conversation. And please put your questions in the Q&A. And I'll get in there as soon as, after about 30 minutes between Julie and Clea. So over to you.
Thank you very much, Martha. And it's great to be here again. Thank you very much for organizing this. And Clea, it's good to be doing something with you again. So I think the way that we're planning to do this first piece is for me to do a little bit of a NDAs 101 overview, because there's so many misunderstandings and confusions, I think, about non-disclosure agreements. And I want to make sure that we're sort of on the same page. But I am, yes, doing this as part of a kind of growing public education and legal education effort, not just here in Canada, but also in the UK, where my co-founder in the Can't Buy My Silence campaign, which is our campaign to ban non-disclosure agreements for anything other than their original purpose of trade secrets. My co-founder is Zelda Perkins, whose name you might know. She was the first woman to break her NDA with Harvey Weinstein. So she and I have joined forces for the campaign. And one of the things that we are really trying to promote is just more and more public awareness of what non-disclosure agreements are and how widely they're being used now. And gosh, you know, it's every week that goes by, I'm astonished at, you know, the pervasiveness of non-disclosure agreements. We hear from people constantly. If you go to our website, which is can'tbuymysilence.com, you will see that there are many testimonies there from people who have either signed non-disclosure agreements or who were pressured to sign and push back. There are a few of those. And I think you'll see that the impact on those individuals and the degree to which being silenced about their experiences has affected them is quite staggering, and it's quite horrifying. And that's the reason that we're so clear that this is an exploitation of greater power by one side over the other, and we're looking to make these take these off the table in future negotiations over settlement. So I think that the idea is that I'm going to talk about NDAs 101, and every now and again, I think that Clea will probably disagree with me or something like that, and we can talk about it or not, or perhaps she could add from her own personal experience, seeing the use of these, and by the time we've done that little bit of an overview, I'm expecting that there will be lots of questions in the chat. So we're looking forward to seeing those. And at some point in the next hour as well, Martha, I will say something about the current situation with legislation moving forward in different parts of the world, including, we're hoping in the next little while, British Columbia. So I'm going to do a little update that way too. So let me get started here. Presumably you can see that now. So, okay. So first of all, what is a non-disclosure agreement? I think this is a fairly non-controversial definition. A non-disclosure agreement, and they're usually, of course, called NDAs, is a contractual agreement whereby one or more parties agree not to disclose material or knowledge that is designated as confidential to third parties. And this is something that I'm going to talk about in a few minutes more in terms of, what does this actually look like and what is and what isn't a non-disclosure agreement. But basically the idea is this is something inserted in a contractual agreement, a settlement agreement that says that certain kinds of information will not be disclosed, will remain confidential. And as I'm going to explain, one of the things that is really, I think, important to understand and pernicious about NDAs is that these agreements to keep whatever the material is or the knowledge is confidential, these are permanent agreements. These are agreements that, follow you to the grave, if you like, and I'll explain the historical reason for that in a moment. Now, the other part of this that I think people are also increasingly familiar with is this idea of non-disparagement clauses. And I call them, not particularly technically, but just as a turn of phrase, the first cousins of NDAs, because effectively they are NDAs, but you often see them in a separate clause in a settlement agreement. And a non-disparagement clause says something like what it says on the left here. This individual will not make adverse or derogatory comment about X and shall not do anything which shall or may bring X into disrepute. Non-disparagement agreements are in some ways even more horrifying from the non-disclosure agreements because they are so incredibly broad. I mean, if you look at the words there, and you don't need to be legally trained, I think, to get this. Basically, you're promising not to do anything that the other person, in their view, thinks damaged their reputation or their image in some way. So we're not talking about any kind of an objective standard here. We do, yes, have defamation laws which protect people against untruths, but this goes even further than that. This is not just saying you can't tell something that's not true. This is saying you can't say something that the other party feel has damaged their reputation in some way. So, this is enormously wide. And again, this is intended to be forever. So a little bit of history, I think, helps to understand this. NDAs began back in the 1980s when there was a big tech boom and there were lots of companies coming up with innovative software and all kinds of code that, had a lot of commercial value. And they didn't want people moving from their organization to another organization and taking all that lovely commercially valuable information with them. And so they were historically initially being used in the 1980s by tech companies in the first place. That was the first sector that really developed NDAs for high-level employees who would be moving to another position in another company. And they were individuals who had had access to trade secrets of some sort in relation to their, their commercial property. That is the property that they were developing as technology companies. And the reason that NDAs were actually developed was because historically, the way that people have been prevented from taking secrets or taking client lists, anything that was commercially valuable to another company when they left the first, used something called the restraint of trade doctrine, which is a common law doctrine that says you can restrain somebody in their commercial activities if there's something that needs to be kept secret, or it's fair for it to be and reasonable for it to be kept secret for a particular length of time. But those were time limited. So restraint of trade, has a whole history of case law with courts saying, no, 5 years is long enough, or 3 years is long enough, whatever it might be. And so the whole idea of NDAs was that they would be permanent, that they would not be constrained by restraint of trade doctrine. And instead, they would simply be an undertaking that would last forever. Now, this has actually become, even more kind of egregious in the last little while, because we saw, for example, if any of you followed the awful story of Virginia Giuffre's agreement that she made with Jeffrey Epstein, which became important again recently because she was then suing Prince Andrew. And there was a clause in that agreement that said, not only would she not sue or bring any kind of action or claim against Epstein or others, but her successors couldn't either. So effectively, this was not even just to the grave, it was beyond the grave. And we're seeing, increasingly those kinds of constant creep of the use of NDAs. And although they were originally introduced in the tech companies at the point of departure, increasingly, and we've seen this since then across many, many sectors, of course, not just tech, they are also being given to people to sign when they arrive at a place of employment. Now, I want to be really clear. The campaign does not have a problem with people protecting trade secrets. Whether that is, you're going into an organization in which you're going to be handling commercially proprietorial information, or whether indeed you're leaving and going somewhere else. So the campaign is not about trade secrets, which was what NDAs were originally for. The campaign is about putting this back to where it was originally, which is only to use NDAs for trade secrets and not to also use them, as we're now seeing, to cover up all kinds of misconduct. I mean, to put it really simply, every kind of misconduct that goes on inside an organization or a workplace now has somehow morphed into a trade secret, at least in terms of the original legal structure here. So employment lawyers, where you're going to see the most use of NDAs, although they also come up in plenty of other areas of law as well, including human rights practices, I'm sure Clea will attest. But employment lawyers estimate, and a number of people who work in that area have told me this, that they see NDAs in 95% of their settlement agreements, that they are part of the standard release. Since the campaign began, I've been collecting NDAs. I have a lot of them now, and a lot of them are very similar. And one of the ways in which they are manifested is within this standard release that says, this agreement withdraws the suit, withdraws the complaint if it's a workplace grievance complaint. And within that release, as we've always called it, there is now almost always something that says, and all matters relating to this agreement will remain confidential forever in the future. And that, of course, includes the identity of the perpetrator, if the perpetrator is a party to this agreement. So I'm going to say a bit more about what they look like in a moment, but a few other just facts and figures around the frequency of their use. We have statistics, quantitative statistics now from our data partner in the UK, and there are also very similar studies with similar results now coming out in the US, that 1/3, 1 in 3 people who report workplace harassment or bullying will end up signing a non-disclosure agreement. And many of those people will also be leaving. They will be terminated with a non-disclosure agreement. It would be very common for somebody who brought forward a complaint, even short of making that a formal complaint, as soon as there is any indication that they are considering making a complaint. I know of many, many cases, I hear this all the time, of people who are then simply sent a severance package, and the severance package includes a non-disclosure agreement, and usually a fairly measly amount of money. Because the other thing that you need to factor into this is a lot of people who are the grievers, the complainers, or the victims of misconduct are also without legal representation. 95% of the people who sign NDAs report consequences for their mental health, and you'll see that if you go and look in our testimonies. People really become, obviously you're not being followed around all day and videotaped to see if you might say anything, to somebody over a cup of coffee about this person. But people really do develop a kind of a siege mentality. And I see this over and over again. People often don't even realize they've signed an NDA until a long time later. And when they do realize, they then feel like, they are at risk constantly of having any conversations that might inadvertently breach whatever it is that they've signed. Because as far as they're concerned, even though Clea and I have many doubts about whether these are legally enforceable in their egregious forms, they still believe they've signed a legal document. And as I know from working with members of the public for the last 10 years, it's what people believe that's a lot more important than what the law actually says. We're also seeing NDAs used preemptively before an investigation or a mediation. This is really important because as a mediator for many years, as an employment mediator, I always had people sign to say that they would keep confidentiality during the process of mediation. Plus, we have other rules about things that are said and offered in mediation are inadmissible in future proceedings. But this is different. And this has just started to happen in the last few years. And I've been having a lot of discussions and doing a lot of presentations to the mediation community about this, because now what we're seeing in terms of mediation is not something that's just for the length of the mediation, not something that's just about admissibility in a future adjudication. We're seeing full-blown NDAs that say they can't talk about anything relevant to this discussion forever. So in other words, I use the word preemptive because they are effectively NDAing people at the very beginning. We see this all the time in universities when they use investigative processes as well as other workplaces, and they ask for NDAs at the beginning of that process. The other place in which we see NDAs being used is where there's some kind of a complaints process in an organization, and there will be an investigation followed by a report, a decision. And very, very frequently, again, the full decision with whatever the investigator has uncovered is not made available to complainants as of right. And I'm talking about unionized workplaces, by the way, as well here. And sometimes we're even seeing people being asked to sign NDAs in order to get the full decision relating to their own complaints. I heard of a case in point just last week, but I've come across a number where the NDA is used before people get access to a full decision. And again, remember, it's forever. So NDAs are used to settle victim complaints. So they could be between the victim and the perpetrator or the alleged perpetrator. And of course, when that happens, effectively, the victim is being asked to, in order to get their own confidentiality, they have to guarantee it to the other side. It's a reciprocal exchange, which of course doesn't take into account the fact that it would be possible just to protect the victim's confidentiality without them having to promise to protect the perpetrator's confidentiality. But the way that an NDA is set up is that it's an exchange, it's mutual. So for somebody is told, in order for you to have your privacy protected, you have to protect the privacy of the other side. And NDAs are also used between employers and employees without the victim being anywhere near. And I've come across many examples of this. So typically where an employee is being terminated for behavior that was inappropriate, the employer will make a monetary settlement and they will include an NDA. Obviously, the employer wants to settle these cases. They want to avoid either an arbitration or a legal suit. So they're interested in making a settlement. But the employee now is accustomed to always ask for a non-disclosure agreement. as part of that package. And that means that the employer is committing to conceal in future any records of any complaints that have been made against that person. I mean, a common clause that I see all the time is an undertaking by the employer to clean the HR file of that employee so that there will be no complaints visible if anybody asks for information, and often to agree a standard short letter of recommendation, which is supposed to supersede anything that anybody else might say in a reference. And that letter of recommendation does not say that the person was terminated for harassment or racism or discriminatory behavior or whatever it would be. So why? Well, because both the employer and the employee have the same interests. They both want secrecy. The employee wants secrecy because they want to get another job. The employer wants secrecy because they don't want the stain of somebody having worked for them who is now being dismissed for misconduct of some kind. Now, you know, if it was the very first time there'd ever been a complaint and they acted immediately and did the right, you know, did what was appropriate, investigated and followed up accordingly, then I don't suppose the employer would have a problem with people knowing that. But of course, the reality is that by the time people are actually dismissed for misconduct, they have usually been doing whatever they've been doing for a long time. Almost always there are multiple previous complaints that either haven't been formally processed or they simply haven't been taken account of. So the employer doesn't want to look like they were dragging their feet and harboring somebody for all those years. And the employee wants secrecy so they can get another job. So they have a perfect alignment of interests. And in these cases, victims are not involved. This is just between the employer and the employee. So a couple of typical clauses that you'll see. It's very common to see a prohibition on speaking to family, friends, and access to professional therapy. It's actually explicitly written into many NDAs that I see. It should be said, though, even when it's not explicitly written in, people often assume it because of the vagueness of the language that is otherwise there. And it's not clear to them that they can, but there is also often a very explicit prohibition. This is an interesting one, I think, in the workplace. There's often a prohibition on encouraging or participating in any other complaint against the same individual or corporation. And this becomes relevant, obviously, if there are subsequent complaints and this person doesn't feel that this person is then told they cannot talk to anyone else about their own experience. I've also seen this happening to prevent people participating in future class actions once they've left the organization. So that's pretty common. There's usually a list of permitted advisors, your tax advisor, your legal advisor, and sometimes therapists make that list, but it always comes with a responsibility on the individual who's signing to ensure that that third party keeps confidentiality, which of course, you know, none of us have that much control over other people's behavior. We can, of course, tell them it's confidential, but this effectively, again, really intimidates people who sign these agreements because they, you know, they're thinking, how am I going to ensure that this person doesn't break confidentiality? You know, it's my fault. I've also seen penalty clauses. It is assumed by people who sign these that if they break the agreement, then they will get their settlement taken back. But in addition to that, I've also seen penalty clauses that say for the first breach, you know, there will be an additional penalty of X, Y, and Z. And again, I mean, I think it's quite possible, and I'm sure Clea can, you know, chime in on this, that these actually aren't enforceable as penalty clauses, but they're there and people read them and they have numbers on them, and those numbers are scary. So is it an NDA? I thought it was useful just to think a little bit about, you know, what is and what isn't, because obviously in the campaign, we're trying to be really clear about what it is we're trying to ban. And first of all, something that's just a one-sided confidentiality or privacy clause that just protects the victim is not an NDA. That's not mutual. We're not trying to ban one-sided confidentiality clauses that protect the victim. In fact, it seems to me that a huge amount of this problem would be solved if we simply started assuming that the victim has a different entitlement and right to confidentiality than a perpetrator does. But at the moment, we're basically putting them in the same bag together. But an NDA is not a one-sided confidentiality clause. It's also not, as I mentioned earlier, process confidentiality. So for the duration of this mediation, for the duration of this investigation, that's not what we're talking about here. We're talking about mutual, and we're talking about indefinite. That's what NDAs are. Now, one of the things that comes up a lot, because it's always been an issue in practice, and I mean, I have my own feelings about this, but is there's been a long-standing convention that we keep settlement amounts, the actual dollar amounts that are in settlement agreements, secret. And you'll see, if you look at the legislation, which is passed now in Prince Edward Island and is going to be tabled shortly in Manitoba and Nova Scotia, that there is actually, and in Ireland, there is actually a clause in there that exempts agreements over settlement amounts. So that long convention, which I have mixed feelings about myself, but that long convention that has been around much longer than NDAs, that you will be able to speak about anything to do with the settlement except for the settlement amounts, the actual amount of money, that's in itself not seen as an NDA, and it's being excluded and exempted in the legislation if it's just about the settlement amount. And then the last thing I've got on this list that I think in some ways is the most important is that usually what these agreements say is that the terms and the existence of the settlement is part of what is confidential. And occasionally, or not even occasionally, I'd say, you know, in the ones I've looked at, probably in at least a third or a half of these agreements, that will specifically talk about the underlying facts of the dispute. And, you know, for some time, there's been this concern that, you know, well, if it's just the terms of the agreement, that's not actually stopping people talking about the underlying dispute. But, you know, it's pretty much impossible in practice for somebody to talk about what happened to them, their experience of being sexually harassed, their experience of being racially bullied, unless they can talk about the actual settlement that then came out of it as a consequence, or the end point of that grievance or that legal action. So although it sounds appealing that you could say it's just the terms of the settlement, it's not the underlying facts of the dispute, what we have seen, and certainly what people in practice assume, is that if you're told you have to keep all the terms, not just the amount, but all the terms of the settlement confidential, then that also in effect stops you talking about the underlying facts of the dispute, because it's really hard to do one without the other. So the consequences: permanent gag on victims. They allow people who have behaved abusively and possibly in some cases rising to the level of a criminal offense to either stay in that workplace or to move on with impunity. It's described as passing the trash, and it's a practice long associated with churches, but we have seen it being done just as frequently in schools, universities, hospitals, and many, many private corporations as well. NDAs protect the employer's reputation because they are not seen as being, you know, complicit in some way if it's taken them years to actually get around to doing something about this, and the career of the perpetrator at the expense of the victim, who, as I've said, could be protected with a simple one-sided confidentiality clause. And we also know that people increasingly are aware, if they work at a workplace where others before them have made complaints and have been NDA'd, and of course, word always gets around, it means that the climate for reporting any kind of harassment or discrimination is really considerably chilled. People know that they're likely going to be asked to sign an NDA. And if they know that before they even complain, we know that discourages people from complaining. I mean, who would want to do that? Who would want to put themselves in the position that for the rest of their lives, they're afraid to talk about something that was a really traumatic but significant event in their lives? And so the idea that they're anticipating signing an NDA is actually putting them off complaining at all. And the other thing that sometimes is overlooked is that if there's an NDA in place that says, you know, so-and-so left the university and they were a jolly good teacher and a jolly good researcher, it says nothing about the real reason that they're leaving. That effectively requires the other people around them in that workplace to dissemble or to tell lies about why they left. Or risk being sued for defamation, which was what happened to me. Because if the truth is hidden in an NDA and the documents showing the truth are hidden behind an NDA, that means effectively anybody else who's asked for information about this risks a defamation suit if they speak up and tell the truth. So that's another dimension of all of the different ripple effects of these that I think is sometimes overlooked. So are they even enforceable? There's a lot of US cases now coming through. We've just seen one case so far that's really important for this in Canada, in Ontario, in the Court of Appeal. But I think that we're going to see more cases likely if we follow the same kinds of reasoning that we're seeing south of the border. There is a particular concern about settlements that involve public institutions and use taxpayer money to pay for NDAs, which, you know, seems to me that it's immoral whether it's a public or a private institution, but there certainly seems to be in the case law a particular concern about public institutions doing this. Obviously, where you're talking about a settlement agreement between a victim and a perpetrator or an employer, you're talking about a lot of inequality of bargaining power. And that's actually what the Uber case rested on, which struck down a mandatory arbitration procedure that Uber was using on the basis of unequal bargaining power. And they're exactly the same arguments as for NDAs. And then two things that you learn about in first year law school really ought to make these agreements unenforceable. One is duress, because people are clearly duressed into signing them. We collect in the course of the campaign information from people on, you know, how long did they get to consider this before they signed it? Did they actually get any independent legal advice or any kind of legal advice on this? Were they allowed to, you know, have a cooling off period to consider this, to reflect on this, to talk to their family and friends about it? Well, often they've already been told they can't talk to their family or friends, so they don't have anyone to talk to. And I mean, all I can say is that I just hear stories of shocking duress around this over and over again. And related to that, lack of informed consent. I think I've said to Martha and Clea that I don't think I've met anyone yet, and I've talked to a lot of people now, who really understood what they were signing at the time they were signing it. Sometimes people don't even realize it's there because it's buried in the like fourth schedule. But also, you know, very educated, very intelligent people sign these agreements, but they sign them at a moment when they are incredibly emotionally, you know, distressed and just want this over, just want it to be done and to get out of that room. And so there are huge problems around informed consent. So I'm going to stop there. I'm going to say a bit about the campaign in a while, maybe in the last 5 minutes, and say a little about what we're doing so far. But I think it's time I stop talking and let Clea jump in here and any questions as well.
Well, thanks for that, Julie. That was very comprehensive. I mean, I think from my point of view, it's interesting. I think the practice in BC is a bit different. I don't routinely see NDAs in every agreement. I think that they're more of a specialty event when there is a particular sensitivity about particularly the victim talking about what happened. And I do think that for my clients, there is a difference between talking about the amount of money they got or talking about whether it was resolved. As long as they can say it was resolved, I don't think that has nearly the same impact on people as being told you can never talk about the underlying events again. So I do make a real distinction between those two kinds of confidentiality agreements or NDAs. And, you know, it's pretty consistent that one would be required to not talk about an amount or other terms of a settlement, I think it's, and I always treat it as rare and wrong for people to be asked to keep things confidential about what actually happened underneath. So I would say here the practices definitely isn't universal, but it doesn't make those agreements any less problematic. And of course, a victim or a survivor of misconduct always has the choice not to sign, but there's always a consequence for not signing, which is that then the case can't be resolved, and you either have to drop your complaint or you have to be prepared to take it all the way through hearing, and that's not, often what people have the juice for. And so that's the bind that they get into, is that they would like to walk away from it other than simply by dropping it.
Can I just say something on that point though, Clea? Because I mean, we have got data, and there's nothing in the data that suggests that the practice is any different in British Columbia than it is anywhere else. But on that particular point of walking away, what I think people don't understand, and again, remember, most of these folks do not have lawyers with them.
Sure.
And they're being told by the lawyer on the other side, this is normal, everybody does it, just sign it.
Right.
And I think what maybe, is not fully understood is that, first of all, when people see you've got to keep the terms of the settlement confidential, that means to them the underlying facts in the dispute. And I still say it's really, really difficult. And I went through this myself when I was being asked to sign an NDA, to talk about what happened to you without referring to the settlement. But in terms of pushing back and saying, I'm not signing, what we're seeing is that when people do push back, when the victim says, I'm not signing this, that often, very often, in fact, they still get a settlement. And the reason they get a settlement is because if you think about it, it's all a gigantic bluff by the other side. The last thing the other side wants is for this matter to end up at a human rights tribunal hearing or in a court, because then it is going to be public. It's going to be exactly what they didn't want in the whole first place. So I think this whole idea of you must sign, otherwise you're not getting anything, is actually kind of a bit of a bluff, a bit of a, what's the right word for it? It just doesn't pan out like that, because in fact, when people push back, and the alternative for the other side is going to be putting this into the public domain, they don't want to do that. That's exactly what they don't want to do. And so then they get given their settlement anyway.
Yeah, and sure, that does happen. I've had both things happen. I've had employers walk away and say, fine, see you in court. And I've had employers, knuckle and take particularly take the NDA out or the non-disparagement out. So you're right. I mean, what happens next in the negotiation is a question of where people's fears are. But certainly if you're going to say no to an NDA, you have to be, I think, emotionally prepared for them to walk away from the table. That's where you have to go as the person who's being asked to sign it. You have to make your peace with them saying, fine, see you in court. And, having to then address that either by withdrawing or continuing. But yes, you're right. That is not always the outcome for sure. And I always say to people, we should push back. We 100% of the time push back. I'd say, maybe 20% of the time that's successful in getting them to stand down. Otherwise, it just, it ends the negotiation and we go forward. So I think it's, and people don't always want to go forward. And I think that's the difficulty with those asks, is that people feel very much that they would like to settle. And so then they agree to something. And you're right. I think that it's difficult for people to, even with a good explanation about what it means, to understand how it's going to feel. And I think, as you point out, how it feels is that this person or this situation that someone's already spent a lot of time worrying about continues to be something they have to worry about. And they have to continue to think, not what do I need, but what does that person need? What are they going to want from me? What's going to piss them off? Mm-hmm. And I think that having to continue to worry about that person's interests is very damaging, actually. Yeah. And that's the expression of power that someone who's a victim of misconduct has already been experiencing for a long period of time. And so it's really,
you're still wrapped up with them. I mean, one of the things that lawyers say all the time to clients in these situations, victim clients, is it'll bring you closure and you can move on. But I mean, I used to hear this constantly from lawyers, but if you actually talk to people themselves about this, it's the opposite. It stops them moving on. Yeah.
Yeah, no, I totally agree. I think that is the harm of them, quite apart from the actual legal risk. And truthfully, at this point, I've never seen someone be sued over breaching a confidentiality agreement, but I'm sure it happens. I haven't had that happen in my practice, but definitely it means you've got to go on in this, intertwined mental space with this, this person who's conducting themselves in a way that's really harmful to you. And, why in a way would you ever want to sign up for further thinking about their interests? Like you're right. It's completely contrary to what your interest is, which is actually closure. I would say here as well that it is routine to get exemptions for family members, caregivers, legal and financial advisors. I get that always with very little effort. So that,
but on the other hand, people who don't have lawyers representing them, and that is most frequently the case, they do not. I see those clauses in lots and lots of NDAs. So
sure, and I mean, full caution to anyone signing a document like that without getting legal advice. Like it, and I think the legal advice that's required on a document like that is not. We're not talking about thousands and thousands of dollars. I mean, it is difficult that people sign them without getting legal advice. And they're usually signing an agreement that says, I had the right to get legal advice and I had an opportunity to do so. And, if people do that and don't get legal advice, the courts will not be sympathetic to them. And so, part of the information that I always want to give is get legal advice. If you're signing a document that says you got legal advice or you had the right to, probably you should get legal advice before you sign it. But it's true. I mean, people.
But the other practical problem for people, not just the fact that, they may not have the funds to do this. There's a couple of other practical problems which I'm really aware of because of the work I've done with self-represented litigants for the last 10 years. One is that people don't know who to go to. Who do I ask? And the second one is that there are still, obviously with you as an honorable exception here, Clea, but there are honestly, believe me, very few lawyers that I can refer people to in Canada who I feel confident will explain what you've just explained, because the vast majority of people, and this is why ILA, I think, isn't really a solution here. The vast majority of lawyers, because this has become an industry, this is the way to get a settlement. And once you get a settlement, you get paid. The vast majority of lawyers, I'm sorry to say, will just tell people to sign them, that it's normal. They won't give them all of those options and help them think it through. And they will be completely unaware, apparently, of the impact that this has on people's lives going forward.
And I have to say, I've seen that not only, I don't hear from other lawyers on my side of the fence usually, but I've seen it in, proceedings where you have a mediator who's like, why wouldn't you sign this? And that disturbs me. I mean, that to me tells me that they haven't had victim clients. They haven't heard the stories about what it's like to sign an agreement like this. They haven't heard the litany of worries that people might raise with you in the course of the conversation. Well, can I talk to this person? What if this happens? What if this, I mean, I think for anyone in that kind of position to say, yeah, just sign it, that is not a wise, that's a person who doesn't have enough experience.
But it happens a lot. I can see Martha is jumping up and down there, so hey.
Hardly jumping up and down. I think that Clea really covered most of it. It's I act for small nonprofit employers a lot, and I think that there is a tendency to see things as automatic that are not necessarily so. There is often a lack of experience when you have very, especially in the world of pro bono, it's like they don't have necessarily the kind of expertise or the experience that would suggest maybe I should look at this another way. And they don't realize the downsides for a lot of people who, as me as well, have had to sign these things because it requires another level of fortitude that honestly, when you're at your weakest point, it's really difficult. I thought one of the things I wanted to mention that came up for me listening to you again was how, when you go to a job, right? How difficult it is then to, you know, like, let's say the complainant or survivor of whatever is the person who's left the employer, and then they have this gap that they have to account for in some fashion, and they're prevented from accounting for it. And it seems to me that that is as someone who's
Oh,
also
it's
in the
huge. It's huge.
employment
Yeah.
business, I look very closely at people with long gaps,
Yeah.
or even not so long gaps, but there's always that underlying question, you know, if you, why did you leave? And I think that impacts complainants greatly, as much as, I don't know if it is as much as, I think it is, because I think most complainants that I see
Most
are
complainants
people who
leave.
leave. They've left the
There is
employer.
research showing that most complainants leave. And what
Yeah.
you're saying is exactly right, Martha, that people feel like they can't explain why they left. I mean, you know, my co-founder Zelda, case in point, you know, she basically left the film industry because she couldn't explain, you know, she'd signed an NDA with Harvey Weinstein, right? But I mean, we're talking really, you know, bringing it down to earth. We're talking about people who often are doing minimum wage jobs and, you know, have very, very little power and relatively few employment prospects. And of course, if they, you know, can't explain a gap, or if they can't explain why they left somewhere, so they look like somehow they're unreliable or whatever. And again, there is a specific clause in the legislation, just, you know, for the avoidance of any doubt, that says that you cannot make somebody agree to keep confidential the circumstances of what happened to them if they are now being, you know, looked at for another job. There is actually a specific clause that deals with that.
Which I find interesting. I mean, I think, yeah, you know, I think a gap is a problem. Lots of people now, you know, we've had COVID, lots of people have gaps in their employment. I mean, I think most people would be able to say, you know, a dispute arose in that workplace and it's been resolved, but, you know, that's not something that I'm going to talk about. I mean, I think that there are ways around that are not ideal, but are not fatal to a candidate's, you know, future. I think what's actually more difficult is when people get into a workplace and something happens and they get triggered and they respond in a way that is, you know, very surprising to their employer. That's actually the moment that I think people very frequently would need to say, I know you think I freaked out in that meeting and here's why, or I know you think that I,
yeah,
you know, because this is bringing all this stuff up for me. I'm going to, you know, I'm going to need some patience and TLC around this, and the legislation doesn't address that, and I think that's a
well, but the legislation will make the NDAs unenforceable in the first place. So can I just put the last few slides up and talk about it? Sorry, go ahead.
Yeah, sure, go ahead. I mean, I think the exemption for the employment situation is there for a reason, and I do think that the fact that it only applies at the front door is too narrow, and that it would be good if that specific exemption, because the legislation does permit people to, you know, agree to an NDA if various conditions are in place.
Right.
But still it says there's some terms that will never be enforceable, and one of which is a term that constrains what people can say coming in the door.
Yep.
And I think that to me, that term is too narrow, and it should include something that anyone needs to say in the course of their employment, whether it's at the front door or some later point.
That's a really interesting point.
One question that has come is in the Q&A just before you segue into the campaign, which I think we all agree is important, just in the interest of giving people an opportunity.
No, I want people to be able to ask questions. Yeah.
There is a question: is an NDA void if the individual is receiving therapy for their mental duress? And I think it's an interesting question because it raises that people know already when they're in this negotiation process that the individual is seeking therapy. So, like, it does sort of seem to me, how do you enforce when you're being told, whether or not the person is represented by counsel, that they've had to, that they're seeing, you know, they need professional mental
Generally
health.
speaking, if you enter into a legal contract and you're competent to enter into it, it will be binding on you. And so then you have to go, the fact that you're getting therapy for the duress of the experience or even the duress of the negotiation, unless that renders you incompetent legally.
Yeah, it goes to the capacity.
Yeah, then your signature on that agreement is going to be binding on you unless some of the other contract concepts are engaged. And the concepts, as Julie's already indicated, are concepts like unconscionability, duress, mistake. But those categories are they're narrow. And I recently saw a decision that was made in a private adjudication context with an private arbitrator, that had to do with signing a different kind of agreement where I thought the levels of duress were extremely high. And the adjudicator was, yeah, he signed it. She knew what she was signing. Too bad for her. So, I don't feel very comfortable saying to people, oh, don't worry about signing it. You were under duress. Like, I think making those arguments in court, you're not going to win those every day.
Yeah. Do you think that it makes a difference in the grievance arbitration environment where people are represented by a union? So in fact, there is an advocate at the table,
because unfortunately, what I hear constantly, and this is another, huge issue that we have in this campaign, I hear constantly, and I know myself from my own experience, that unions are complicit in this. So union representatives are no better at this point at telling people not to sign NDAs than, many lawyers who would do them in the normal course of practice. It's another of the problems. I hear stories all the time from people whose union representatives talk them into it. Because I think that they don't fully understand the implications of it. And I think that they've bought this idea, that it's normal and it's what we always do. So can I just maybe say a little bit, oops, Daisy, about the, okay, I only have that one. Let me say a little bit about the legislation just really quickly, because I think it's important that people understand this, and I'm happy to send it out to anyone who wants it. The legislation was originally designed and developed with an Irish senator named Senator Lynn Ruane, and she's now putting this legislation through the Irish Senate, and it'll then go to the Dáil. The government has said they'll support it, so we do expect it to be passed. We then took that model and we introduced it through in Prince Edward Island, although they actually managed to get an even broader version of it through, which was somewhat amazing. And what I would call the Irish legislation is now being tabled with some jurisdictional specific tweaks in Manitoba and in Nova Scotia, and it's being looked at by BC. And what it does is it says, what we decided to do, and this is, a strategy, was to put the arguments against NDAs into the bill. So now, once the bill is law, it means that the employer will have to show, or whomever the perpetrator who wants to uphold the agreement, and obviously that's going to be either a perpetrator or an employer, they will have to show that the following conditions are met. First of all, that the victim asked for it. Now, this is because we hear all the time, oh, the victim wants it. It's not because I actually believe that victims asking for an NDA means that they understand what that means, but we hear that all the time. So that's the first criterion. And then they have to meet all of the rest of these, not one of them, all of them. There must be absolutely no duress or pressure. There must be full and voluntarily and well-informed consent. There must be access to independent legal advice. And this is in some ways the most important, this agreement must not harm or endanger any third parties or the public interest. So in other words, if it is an agreement that leaves somebody in a workplace where they can then behave in the same way again, or move to another workplace undercover where they can do the same thing again, that will not be enforceable. And it will be on the employer or the perpetrator to show that no other third parties will be harmed and the public interest won't be harmed, that it was fully, the other side gave fully informed, as Clea was saying, full capacity consent, that they had access to independent legal advice, that they were not duressed, and that they in fact asked for it in the first place. So in my mind, you're not going to find any NDAs in the way that we understand them that actually meet those criteria.
Yeah.
And that was because we decided to put the arguments right into the bill. We could have just written all NDAs will be unenforceable, and then there'll be all kinds of arguments about what does that look like and how can you get a loophole. So what we're trying to do is to close all those possible loopholes by spelling out the conditions under which it would be acceptable, and those conditions aren't going to exist. That's the idea.
Yeah, and I think in that sense, I think it makes it, I understood the theory of it, and it does make a lot of sense for sure.
But there's lots of other ways to do it, and I'm intrigued by your suggestion that we could make the exemption that's very specifically about point of hiring also be throughout employment. I think that's a really interesting idea. And, in case anyone's interested, what PEI did, which was even broader than the Irish bill, because it was originally designed to be amending employment statutes, which of course is always the easiest way of introducing new legislation to amend what's there already. So it's just employer-employee. PEI actually says all parties. And I don't know how many people have actually noticed this in PEI, but it now says all parties. So it's not just workplace. It's all parties in any kind of civil action, including workplace.
Which actually is really important, because these issues arise also in service contract.
Absolutely.
Where people are being provided, and the religious context is a service contract text. Like a lot of contexts, they're service contexts. And so, in terms of the nonprofit community, often what they obviously have employees, but they're also often providing services. And so the fact that, NDAs can arise in the service context is
exactly.
It's good that it's recognized.
Oh yeah, I mean, we saw this only as the first step, so we were thrilled when PEI did this, but Manitoba and Nova Scotia have gone back to the version of workplace, just so that you know. Sorry, Martha.
No, I think, we could easily spend another hour deconstructing, talking further about this. And I think I hope that we have an opportunity to actually do that in in a different way when we have legislation here in BC. Because I think it's extremely important that people, know about this, but also, from my way of thinking, particularly in this province, anything that reinforces the importance of access to informed consent, in access to legal advice, that really encourages perhaps this province to move towards a system that enshrines that and not just in BC, but everywhere, that, we can't do this alone. And, and this is also where the unbundling, I hate to say this, of legal services can be a real problem, which is that the limited retainers of people sometimes mean that they're not spending the time because they know at the end of the day, the value of the retainer is X, and they aren't going to spend more than an hour, when in fact, because of the situation, particularly in service provision, in areas where there might be other issues, they're simply not covered. People can come up with a few $100s for an hour, but they aren't necessarily in a position to think about at that moment when they're going to sign it, that's actually what they need. And what they need is 6 months from now, they need to be able to sit down with Clea, with me, with whoever, and they need to have access to that. And I would argue as well that small nonprofits, that employers need access as well. Because in my experience in this space, which is now 40 years of experience with the nonprofit world, most don't want to hurt people. And they are getting advice from sometimes people who spend their entire day in corporate contexts, and use that term broadly, let's just say resource extraction. and they don't have the expertise with the sector that actually does not want to harm. And if it were explained to them that they don't need the NDA in order to move forward, and that they don't have to fear people who are making complaints, that would go a long way to actually changing this as well. And I think that we're always going to be playing catch up if we don't ever get sustainable, dedicated services in these areas. And I look forward to seeing how we can do that in light of, the new budget federally and the new budget provincially here in BC.
And the gutting of public legal information services at BC Legal Aid. Yeah.
Well, absolutely. I mean, don't even get me started.
Last month.
Like how we.
But I think part of our challenge at the campaign, and I just want to encourage everybody who's interested to go to can'tbuymysilence.com and see what we're doing and what the latest developments are. There's also a lot more public legal information on those pages that will give you, if you're in this situation, you'll see it. If you signed an NDA, we would love you to submit your testimony anonymized. We will anonymize it because we want to protect you at this point. But those stories are enormously important for media stories at the moment to get journalists interested in this issue.
Great.
Thank you.
Well, thank you both for another opportunity to talk about these very important issues. They're near and dear to my heart. And I thank all of the participants, and hopefully many of you will share this very, very timely and important conversation with your colleagues in various contexts. Enjoy the sun, enjoy the day, and we'll see you. Actually, we're going to be talking about defamation in May with David Weatherspoon, who is the lawyer for the complainants, for the defendants in the defamation issue brought by the Professor Galloway, he who shall remain nameless.
Thank you very much, Martha, and thank you, Clea, and everyone who's been here. And if you want to, send email or whatever, got questions, just get in touch with us. Okay, take care.
Take care. Thank you. Thanks, Julie, for that thorough review.